Hello friends and law fanatics, myself Lakshay, a legal intern from LEXIS and Company. Today I am going to talk about strict liability and vicarious liability. Strict liability in India refers to the legal principle where a person can be held liable for harm or damage caused by their actions regardless of fault or intent. The liability is based on the fact that the person engaged in a certain activity that inherently carries a risk of harm. Strict liability is often applied in cases involving hazardous activities, dangerous substances, or declarative defective products. Section 268 of Indian Penal Code (IPC) deals with public nuisance and imposes strict liability for any or omission that causes harm to the public. Section 357B of Code of Criminal Procedure provides the compensation to victims of certain offences, including offences under strict liability. Now we will talk about vicarious liability. Vicarious liability in India is the legal doctrine that holds person or entity responsible for their actions or commission of another person based on a certain relationship or connection between them. And often it arises in situations where employees can be held liable for the acts or of their employees performed within the scope of their employer. Section 2, Subclause 1, Subclause D of the Consumer Protection Act 2019 holds a person responsible for the actions of their employees or agents in cases related to unfair trade practices or deficiency in services. Section 10 of the Employers State Insurance Act imposes vicarious liability on employees for the payment of contribution and benefits under the Act of Employees. The section are provided examples of relevant provisions in Indian law, but it's important to note that the application of their liability and which can be strict liability or vicarious liability can extend it beyond the specific sections. Thank you. I am winding up this video. If you have any doubt, please let me know in the comment section.